Alex here with part 75 of the My Docket series on child custody and visitation. As with my previous video, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex-parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. I mentioned in part 73, the previous video, that this video would go immediately into my petition for writ of mandamus filed in the Supreme Court, but it's not this video. I was one video off. That will be happening in the next video, part 75. This video, part 74, will be going over the order, the final order that was entered following the hearing video in part 72. So the times got a little bit mixed up in my head, but we are, proceeding forward chronologically, and it just so happens that the next thing that occurs in the case is the entry of the judge's order after hearing. That is the final written order. That is the order that controls going forward. The oral pronouncements from the bench that were, stated by the court in the actual hearing video themselves have no effect at all. It's the final order that will control the case. I talk about this in the video proposed order. Please watch that video if you haven't seen it yet, because I explain the importance of understanding that you have to pay careful attention to what gets put into that final written order, because that's going to be what controls your case, not what was said at the hearing. And that frustrates a lot of people, especially people who are representing themselves, because oftentimes they get taken advantage of. They will win their hearing, and then the attorney will leave things out when they prepare the proposed order. Their ex's attorney will. It's not a problem so much for a person who has an attorney, because typically the winning party's attorney gets to prepare the order. It typically happens with unrepresented parties, because sometimes the judge will say, hey, I know you won your case, but since you don't have a lawyer, I'm going to ask your ex's attorney to prepare the final order. And they will sometimes play games with that part of the process. They will add things in that were never mentioned. They will leave things out that you were supposed to have gotten. It happens, and I should go ahead and mention that even if you have an attorney, please double check them, because sometimes people with an attorney will get a proposed order that's missing things because their own attorney overlooked them. It does happen. The last thing I'd like to mention before we go into the mindset is, or in fact, let's just go into the mindset. Why not? I was happy. I won my hearing, and I was expecting a final order that was going to not only put my son into the school, Coral Academy of Science, that I had wanted, but also end one of those two horrible midnight exchanges. Not only does it end one of the exchanges, it actually ends up completely eliminating the conflict with regards to visitation exchanges altogether, because the one exchange that does continues to occur at our son's school. And that's the 3 p.m. Pickup and drop off. We no longer have to see each other. That is something, we still have the Sunday. Okay. So we go from 4 face-to-faces to, I believe, just 1 face-to-face. Because we had a pickup and drop-off that happened in the middle of the week, and a pickup and drop-off on the weekend. The pickup and drop-off in the middle of the week switches to just an exchange that occurs at the school, so we don't have to see each other. We can pick them up at the school. I think I'm the one that drops them off in the morning, and she picks them up after school. And then we've got the other remaining midnight exchange. So there still is one exchange where I have to see her. It's still one midnight exchange. But that's a whole lot less than what would have happened had the school she chose been selected by the judge, because then we would have gone with her visitation schedule, which would have continued that gap in the middle of the week, which means 4 face-to-faces. So anyway, it gets a whole lot better when this final order gets entered. And there is one more thing that I want to talk about, is that's that the attorney that was representing me gets switched out with another attorney who is still a friend of mine, who will still represent me for free. I wanted to talk a little bit about that. The reason that I decided to not just take my case back over and ask another friend to continue to represent me was because I imagined that my ex would kind of back off. For the entire case, I had always been unrepresented. And I had always wondered if she would try so much to take advantage of me if I actually had an attorney like she did. And so I knew my friend Clifton Young was not going to continue to represent me. He indicated that it was just for the hearing, and that was all. I appreciated what he did for me. We did win that hearing, but I was thinking to myself, maybe I can ask this other friend of mine to represent me for free, on the basis that if she is representing me for free, my ex will just kind of knock it off. She'll just back up. She'll stop trying to take advantage of me. She'll be more reasonable. And this was sort of my thought process. Well, what ended up happening was our son was acting out a lot in kindergarten. He was only 4, and the teacher asked if we would be okay with him still going to Choral Academy, but holding off for a year. So basically, next year he would come back, he would get to re-enroll. We wouldn't have to go through the lottery or anything like that. It would just be a 1-year suspension in his education, and he would come back at age 5, just as if nothing had happened. My ex agreed to this, but as soon as we got home, she sent me an email saying, hey, since the school doesn't want him, I'm going to just enroll him into the public school. That really ticked me off because I'd gone through all this work to get him into this school. We went through motions. We went through a hearing. It was a very stressful hearing. We both had attorneys. And she agreed at the meeting with the teacher. She stated, yes, that sounds good. And for her to walk out of that meeting, and I don't even think it was a day later, send me that email saying, hey, I'm going to just go ahead and enroll him into school. For her to do that, that just showed to me she could care less that I had an attorney. And in fact, maybe she thought that I was paying attorney fees and that it was a way to continue to cripple me financially. So I ended up, it's not long later that this attorney ends up getting off the case because I'm going to need to litigate other issues. But I did want to let people know a little bit about sort of the thought process behind substituting one attorney out for the other. And I suppose at this point, we may as well just go ahead and get into what the judge has filed. Here we have the judge's order after hearing. So in the first paragraph, he summarizes the fact that we both appeared before him at a hearing on July 21st. He indicates that I, the moving party, and petitioner natural father was represented by my attorney, Mr. Clifton Young, and that my ex, natural mother, appeared through and by her attorney, Catherine Burney. Next paragraph, the court indicates that I preferred that our son attend Choral Academy of Science, and my ex preferred that he attend Roland D. Elementary. We agreed to certain procedures, and we agreed, or the attorneys at least agreed, that if the court selected my ex's school, we would adhere to her schedule, and then if the court selected my school, we would adhere to my proposed schedule. Next, we have the court concluding that our son would attend Choral Academy as the best educational opportunity for him at the time, and the court indicated that our son would attend the first semester as a half-day kindergartner and the second semester as full-day kindergartner. I didn't really care one way or the other about that. I don't know why that was turned into such a big issue. Next paragraph, the court having selected the school that I chose, the timeshare that I proposed will now be implemented, which was a huge boon to both me and our son. So the new schedule would be that let's see here. It looks like I get him at 3 p.m. on Wednesday and I keep him until midnight at 12:30 on Sunday. And this is basically 2 exchanges a week. So we've gone from 4 to 2. And for simplicity's sake, if he is in school within an hour of the 3 p.m. exchange, then we will I will instead collect him directly from school. So we go from 2 to 1 face-to-face. That's huge. From 4 exchanges to 2 exchanges, from 4 face-to-faces to 1 face-to-face. This is a huge reduction in the conflict between myself and my ex. A tremendous move in the right direction. Next, we have a review hearing that is scheduled or going to be scheduled in May of 2012. I don't remember what happens at this hearing. I really don't remember the school issue being addressed at all. So I think it's just something that he did just to sort of appease my ex. I talk about why judges do this in the video Meta Rulings and also in the video Best Interests of the Parents. Next, we have the assertion that we will communicate only by email in relation to our son with the exception of emergencies. This is a step in the right direction, but it is not the end of this particular conflict. My ex will continue to exploit communications up until the court orders us to use our family wizard, and she will even continue after that point, up until the court deprives her of legal custody. If you want to learn more about why that happens, please watch my video, Modifying Legal Custody. The court then indicates that myself and my ex are to attend co-parenting classes. I think I have a video on what I think about these, and it's titled Court-Ordered Classes, something like that. My ex's request for attorney fees is denied. And then the court goes into the standard boilerplate with the next 1, 2, 3 paragraphs. These are the paragraphs that discuss that you have to abide by these orders of the court. You can't take your child and abduct them, run off with them, keep them from your ex. If you do so, you're committing a Category D felony. And the court also mentions that the Hague Convention is in effect, which is for international child abductors. Next, we have the certificate of service by the court, which indicates that this order was submitted electronically to both myself, or actually to my attorney and my ex's attorney. Next, we have the substitution of counsel that was filed by my attorney. And this is a way for one attorney to cede power to the other with regards to a specific client, which is what you have here. It contains all 3 of our signatures. The thing that is unique from a substitution of counsel and any other motion that is filed to either remove an attorney or for an attorney to withdraw from a case is that with this particular document, the court doesn't need to review it, approve it. The court's not involved at all. It just happens. And with those other types of documents, the motion to withdraw or the motion to remove your attorney, those require the court's approval. And so this is just more seamless. Affirmation, which indicates to the clerk of the court that this document doesn't contain a social security number, and the certificate of service pursuant to Rule 5, which indicates to the court that this particular substitution of counsel was sent to my ex's attorney by mail. So now my ex's attorney is aware that Clifton Young is no longer my attorney of record, and that Monica Caffaratti now is my attorney of record. Request for submission. This is a document that submits to the court the proposed order after hearing. If you want to know more about what a proposed order is, please watch the video Proposed Orders. There's a whole lot behind that process, and it is not something that you should glaze over at all, especially if you're representing yourself. It is a must watch. Now we have a list of exhibits, which is Exhibit 1, the final proposed order. Exhibit 1. And here's the order after hearing that we already went over. So I'm not going to go over it again. As with my previous videos, if I find a document that I've already gone over, I skip it. If you want to know more about this particular document, you can go ahead and click on the links down in the description below to download it for yourself, review it. And if you see something that I missed or that you think I should address, just mention down in the comments below and I will address it. Notice of entry of order. This is a document that I have covered a number of times, and it is much more serious than it looks. If you want to learn more about the notice of entry of order, please watch the video titled Notice of Entry of Order. Besides letting your ex know that an order was filed, it also controls the time limit to file an appeal, and that is a big deal. Next, we have an affirmation indicating that the notice of entry doesn't contain a social security number, and a certificate of service under Rule 5 that indicates the notice of entry of order was mailed to my ex's attorney. Minutes. The minutes are basically the notes that were taken from the hearing, and the final order obviously supersedes these minutes because it's a formal written order signed by a judge. Minutes are typically prepared by a clerk that's sitting by the judge and typing away as the hearing goes on. So this does not count as a court order, and it contains a summary of what happened at the hearing and usually ends up in the order, but not always and not usually with the same sort of type of language. So if you want to review the minutes for yourself and ask me any questions about them, go ahead and do so. You can click on the link, download it, and post it down in the comments below. But for the most part, I will be skipping over the minutes because the order supersedes it anyway. Notice of declarations of school teacher and dean. Okay, so if you want to know why I went ahead and got hold on a second. Hold on, let's go through this. Rule 5, certificate of service indicating that this notice was mailed to my ex's attorney. Exhibits 1 and 2, declarations. Okay, yeah. So first thing I want to mention, before I mention what I was about to mention, is that I don't see why these declarations were attached to a notice. I don't understand why at all. These declarations could have been filed as their own paper into the docket. They didn't have to be stuck into a notice as Exhibits 1 and 2. For whatever reason, we did that, and now, knowing what I know, this is just not something I would do. I feel like it's just more confusing than it needs to be. If you have an affidavit or a declaration, just file the affidavit or the declaration, just on its own, independently into the docket. Exhibit 1, which is the declaration of Alicia Del Rio. This is the kindergarten teacher for our son. And by the way, if you want to know why, this is what I was about to talk about earlier. Okay. If you want to know why I prefer to use declarations and affidavits over just a letter, please watch the video Declarations and Affidavits. You can also watch the video Letters versus Declarations. In fact, that might be more on point because that kind of compares and contrasts the two and goes more into my approach. I'm going to resist talking about it now because I have a video dedicated to the topic. So she indicates that she's over 18, she's not been declared incompetent, never been convicted of a felony, not a party to the action, and that our son has been in kindergarten, that she's been a kindergarten teacher for 9 years, and that she served at a Washoe County Conventional Public School for 5 of those 9 years, with the remaining years being served at Corl Academy of Science. I think I put that in there because I wanted the court to know that she had experience in both schools, both the charter school and the conventional public school system. And it was a lot of experience. We're looking at 9 years here. Next, we have an assertion that she has contacted us both, and that having been notified of the order of the court for our son to attend the school, that she, on the 9th of September, had us convene in her office for a meeting, and that it was agreed upon that our son's best interest would be served by suspending his enrollment until the next school year. And the reason I went ahead and got this declaration filed is because my ex was trying to basically renege on her agreement. And so this is a way for me to sort of preempt the shenanigans that she was trying to pull. Next assertion is that our son would be automatically enrolled and that his return was eagerly anticipated by the school. She goes ahead and, oh wait, this is Mr. Tunser's signal. Oh, hold on a second, guys. Okay, I think I got pages 1 and 2, what's the word, interposed, flipped around. So, yeah, okay, so see how this is assertion number 6 and this is assertion number 8? This is supposed to probably be page 2 of the other declaration. So this is going to be a little bit confusing. How am I going to handle this? Okay, so this is how I'm going to handle this. I'm going to go ahead and jump down to page 2 of the next exhibit, and then I'll jump back up here so that this doesn't confuse everyone. Okay, so after she asserts that that she was notified of the court's order for our son to attend Corl Academy of Science, she asserts that on September 9th, she held a meeting with both myself and my ex, and that we discussed his best interests and that we agreed upon the following determinations. And so this kindergarten teacher is basically, for the most part, swearing under penalty of perjury that my ex agreed to this. This is in line with what I was trying to do, which was sort of cut her off at the knees at her attempt to just enroll him in the other school. Subsection A is that it would be in his best interest to not go to a public school. So that's really nice that I got that included in there and that the kindergarten teacher signed it. She thinks that it would be, that he would benefit from an additional year of preschool, and she thinks that, or she's stating that he will be retaining his seat in her class and that he will be returning next year to her class. The next declaration is by Tekken Tunser, and let's see what he's stating here. He's over 18, he's not been declared incompetent, he's not been convicted of a felony, he's not a party to this action, which means he's not involved in the lawsuit. He is the dean of the elementary school at Corl Academy of Science, that he has been in contact with both of us, both myself and my ex, and that he has been notified of the order of the court for our child to attend the school, that our son was enrolled in the kindergarten class for this particular year, and we're going to go ahead and continue from here, that on September 9th, myself, my ex, and the teacher convened in his office for a meeting, and that it was agreed that our son and his best interest would be served by suspending his enrollment, and that he would benefit from an additional year of preschool, and that next year he would automatically have a spot in the kindergarten class. So these declarations that were filed basically are a way that I practice what I preach in the video, anticipating the response. If you haven't seen that video, please watch that video. But in that video, I explain the importance of trying to sort of figure out what your ex is going to pull and cutting it off at the knees, figuring out how to counteract it before she does it. So in this particular pair of affidavits, you can see that I am getting it stated by 2 professionals tied to the school that number 1, it's in his best interest to continue to go to the school. Number 2, he will be automatically enrolled in the school, so there's not going to be any lottery that we have to deal with. And number 3, that my ex agreed to it. Because if she's going to pull a stunt trying to tell the court that she didn't agree to it, there is now 2 professionals from the school saying otherwise. And I'm sure her attorney talked to her about this when she read this. Next, we have a notice of declaration regarding parenting class. And this is in response to the court's order compelling us to attend parenting classes, filed by my attorney. We have a Rule 5 certificate of service indicating that she mailed this to my ex's attorney. List of exhibits, we have a declaration by me. Exhibit 1, a declaration by me. Okay, again, same thing. I don't know why I didn't just file this as a declaration just on its own. I didn't have to staple it to the back of a notice to get it into the court, docket. I could have just filed it. Anyway, let's proceed. So I am stating under penalty of perjury that, number 1, the court held a hearing regarding our son's education. The court ordered us to attend parenting classes. On August 6th, which is the next assertion, I contacted Children's Cabinet and was redirected to, and I named the people that I talked to on the phone, who apparently runs scheduling for classes and appointments. This particular person advised me that the class was canceled, and the former teacher of the class was no longer teaching for Children's Cabinet, plus there were budget cuts, and that her supervisor can verify the information with the court if it is needed. So I'm telling the court, hey, I couldn't comply with your order. It's not that I didn't want to, it's that I just couldn't do it. The class that you asked us to attend is gone. If you want to know my opinion on parenting classes, on orders commanding you to go and attend parenting classes, you can watch my video, Court Ordered Classes. And the final document we have here is the Notice of Rule 9 Compliance. WDCR is a local list of rules. They're called the Washoe County District Court Rules. And let's take a look at what she is complying with. So I am appearing through and by my attorney. First paragraph, that my ex's attorney was served a copy of the proposed order, and that she sent a letter to my former attorney suggesting certain changes be made. On or about the 21st of September, this attorney took over for Clifton Young, and that this attorney made the changes requested by my ex's attorney. So Rule 9 probably deals with proposed orders. I'm not going to go ahead and double check it now because my case is closed anyway. Why bother? But if she's citing this rule in reference to sort of the back and forth negotiations on the proposed order, then it must be a rule that contemplates the proposed order process and what the attorneys have to abide by when they are, preparing the proposed order and getting feedback from each other on what should be in it. Affirmation indicating to the clerk of the court that this document doesn't contain a social, and that looks like it. The court has disposed of my motion to set education and modify timeshare, and the court has done so by granting my motion, sending the child to the school that I had selected, and denying my ex's request for attorney fees. Going into the financials, I prepared, let's see here, the substitution of counsel, the request for submission, and the notice of entry of order, along with 3 more notices packed with declarations. So it looks like 1, 2, 3, 4, 5, 6, 7 documents. Out of those 7 documents, it looks like 5 of those were prepared by my attorney, and those are all free filings, so I incurred $0 in costs. My ex's attorney didn't prepare any of these documents, so she incurred $0 in costs. My attorney didn't charge me anything. She was representing me for free, so I incurred $0 in attorney fees. My ex's attorney would have probably charged 15 to 30 minutes to review that order. And, well, actually there was some back and forth. So it would have been more than just reviewing the order. It would have been making suggestions to my attorney on the proposed order. So I guess for the order lumped in with the request for submission that contained the proposed order, we can say 30 minutes. That's only, it could be much higher, but she went to the hearing and she represented my ex at the hearing. So she's going to have a strong grasp as to what happened at the hearing and what was expected. And so for those reasons, I'm just going to say a half hour for reviewing of the order and the feedback in the proposed order process. So we're at a half hour so far. The substitution of counsel, maybe 15 minutes so that she could update her systems and have the information there for my new attorney. So we're at 45 minutes so far. The notice of entry of order and the minutes are, let's just say 5 minutes for those 2 documents combined, which gets us to 50 minutes. The declarations are interesting. They're not very long, and you don't really have to do anything about them. They're just being filed without anything really pending. She might have sent them to my ex sort of in an email and said, hey, take a look at these. I don't imagine she spent a lot of time on them, at least not at this juncture. Maybe later if I rely upon those when I file some kind of motion, but for now, I don't think it's unreasonable to say that maybe my ex's attorney spent 10 minutes on those. So that's going to take it from 50 minutes to an hour. And then you have the notice of WDCR 9 rule, Rule 9 compliance, which is, she's probably just going to glance at that, spend a minute on it. It's negligible. Let's not even count it at all. So all of these filings, we're looking at 1 hour in attorney fees for my ex's attorney. And at the rate of $250 an hour, that's going to come to $250 in attorney fees. If you have any questions, feel free to post them down in the comments below, and I will see you guys next time.